Worst case scenario number 2. If you guys remember back to February when we talked about a lawsuit that was filed in Georgia against Stiizy, cookies, and other companies that are big in the hemp space, as well as some of their labs, wholesalers, and distributors. Well, here comes lawsuit number 2. Hey, I'm Morgan Davis. I'm a business attorney based in Raleigh, North Carolina. I focus on cannabis and wellness. Let's talk about how to keep your business protected and thriving. California-based company Stiizy has been sued in federal court in Illinois by 2 plaintiffs, one based in Missouri, one based in Illinois, who purchased several Delta 8 products from Stiizy in the 2 different states. The lawsuit itself is very similar to the one filed in Georgia, the gist of it being Stiizy purposely mislabels, packages, and advertises its products as legal when it knows that in fact the majority of them are not legal. The lawsuit is a class action calling for others who have purchased Stiizy products to join the plaintiffs and says that the number of plaintiffs could be in the millions. So the current estimated claim is at a minimum of $5 million in damages. We'll be tracking this lawsuit as well as the one in Georgia to see how this proceeds. But the point of it is to look at what the allegations are and what you as a company in the hemp space can take from this lawsuit to try and protect yourself from the worst case scenario. So let's look at the allegations. Claim number 1, that many of the products being advertised are advertised as compliant with the federal 0.3% Delta 9 THC limit by dry weight that we're all very familiar with. Independent testing conducted by the plaintiffs shows that at least some of those products are not compliant. In fact, one that's quoted in the lawsuit comes in at 3.57% Delta 9 THC concentration. Now, why does this matter to you? Whether you are a manufacturer or you are a wholesaler or a distributor or a retailer or even a consumer, it should matter to you because this is something that we know to be true throughout the hemp industry, especially the intoxicating hemp industry, not just specific to Delta 8 products, but applies to almost all products. Whether it's an issue that the manufacturer is making a product that they know to be over the limit, or the wholesaler/distributor/broker is not maintaining the environmental controls along the way, neither is the retailer, and therefore the product which was once compliant is degrading or decarboxylating and becoming illegal, it's irrelevant. Because what we're ending up with is a market that has a massive amount of products that are not compliant in it. Claim number 2, that the products do not comply with federal or state food, drug, and cosmetic acts. So generally you hear us talk about the role of the FDA when it comes to cannabis and hemp-derived products that are federally legal. And their regulations, their authority comes from the Federal Food, Drug, and Cosmetic Act. But most states have their own version of that same federal act, right? Illinois and Missouri both have one. Now, we've known for years that the FDA's position on hemp and hemp derivatives, or actually cannabis and cannabis derivatives, is that they are not appropriate to be added to food and beverage or to be put forward as dietary supplements. Now, there's some rumor that that's changing, and Congress has pushed the FDA to come up with a regulatory pathway for these products so that they can be regulated. And the FDA has essentially thrown up their hands and said, we don't have one. You, Congress, need to create one for us. And now they're going back and forth and fighting like cats and dogs and trying to pass off whose responsibility is. So maybe of that fight, something will come of it and somebody will actually regulate these products at the federal level. But until then, it is clear that the FDA does not permit these products to be added to food and beverage and or dietary supplements. But there's no enforcement of that. So basically, it's a moot point for most businesses. The risk of enforcement is so low, it's practically non-existent, right? And that has been the same case at the state level. In fact, many states have exempted their own acts to say that these products aren't adulterated and not misbranded if they contain hemp derivatives, and therefore taking them out of their state level Food, Drug, and Cosmetic Act. This lawsuit goes back to the original idea that unless they've been exempted, or if they are in some way not exempted by the law, which we'll talk about in a second, Delta-8 synthetics, part of this is the Delta-8 synthetic argument. If they aren't exempted under the current law, then therefore these products are a violation of law that has been in existence for quite some time. And we know all of that to be true. We've all just been banking on the idea that nobody's going to enforce it. But the banking on that has been that no government agency would enforce it. And for the most part, that's been true. What most people have not thought about or not planned for is the idea that the individual consumer would bring a claim based on violation of existing law. And that's what's happening here, is that the claim is Stiizy knows that these products violate these laws and they are producing them and selling them anyway. And in addition to that, they're still advertising to clients that they are 100% legal. The last claim is that consumers wouldn't buy these products if they knew they were over the limit. Now, there are lots of people who are going to say, of course we would. Consumers know that these products are going to get you high. They're hoping that some of the products are over the limit. This is their way to buy cannabis, and we all believe that cannabis should be federally legal and available to all who want it, and all of those arguments that I 100% agree with. But I don't agree with the idea that all consumers would continue to buy products that are advertised as 100% legal if they knew in fact they were illegal. And here's why. There are plenty of people who are not okay with buying something that is not as advertised. There are lots of people who are buying these products because they believe that this is the legal way for them to access cannabis. And so if you sell them something that you tell them is 100% federally legal, and they get a sense of safety from that, of believing that what they take home and put in their home or put in their car or put in their body is legal, and then they find out that it's not. Or worst case scenario for them, they're held criminally liable for possessing something that is in fact illegal. They absolutely do care, and they probably don't want to purchase your product anymore. So this last claim, this last point brings up a growing trend in this industry that we see. There is certainly a consumer who doesn't care how hot or how high or how much THC is in their product, and in fact, they're looking for the highest amount of THC. That is absolutely a consumer group. There is also a consumer group that cares very much that the product is what it says it is. And if you tell them that it's legal, that it is in fact legal. This lawsuit and the one filed in February mark a potential shift for the hemp industry, a potential new phase, a phase of litigation. And not litigation between companies over patents or trademarks, but of consumers holding the hemp industry responsible for what it puts into the market through personal injury attorneys, through plaintiffs' firms. These two lawsuits, depending on how they come out or if there are more that follow them, mark a turning point where the bigger you are as a hemp industry, the more popular, the bigger the target you are. And just like Wendy's or Burger King or all sorts of other food industry operators that we've seen over the years who've gotten sued for misadvertising or misbranding their products, the hemp industry could very much be the next ripe industry for litigation from a personal injury or plaintiff standpoint about this exact issue. That what you put on your product, what you put in your product, and what you tell people in it needs to be the same. It must be consistent. We can't continue to lie about what's in the product. And if we know that the product is going to change from creation to point of sale, we as an industry have to start solving for those issues. We'll be watching this litigation as it proceeds. Come back next month for some updates. And if you're concerned that your business is operating in a way that could end you in hot water, give us a call today. We'd love to help you avoid the worst case scenario.